From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Prosecutors rest their case against Donald Trump in the New York hush money trial, after which the former president presents a brief defense. But as the two sides now wrangle with the judge on the details of how to instruct the jury, does it look like Manhattan District Attorney Alvin Bragg has proved his case? Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnist Kim Strassel and editorial board member Monet Ukwe-Barua. After several weeks of testimony that alternated between dramatic and dry and boring, in a trial transcript now over 4,000 pages, the prosecution concluded its argument that Donald Trump is guilty of 34 felonies for falsifying business records. Just to set the table as a reminder, Stormy Daniels says that she and Mr. Trump had an extramarital encounter in 2006, which Trump continues to deny. Then days before the 2016 election, Trump's fixer, Michael Cohen, paid Stormy Daniels $130,000 to keep quiet. The following year, 2017, Trump repaid Michael Cohen via a monthly retainer as if it was income to Michael Cohen, and that number was grossed up to cover the taxes that Cohen would owe. Those payments are the basis for the charges, and because the DA brought felonies, Kim, he has to prove that Trump cooked the books while intending to commit or conceal a second crime. So, Kim, after hearing from all these witnesses, including Stormy Daniels, Michael Cohen, and more, what is your view of whether DA Bragg has brought the evidence needed to prove his case and get a conviction here?
Yeah, there's two questions there. I mean, one is the underlying crime, as you say, the falsification of business records. And Trump's attorneys, the defense, actually made a number of arguments throughout the course of the trial as to why labeling them legal expenses was indeed what they were, because this is, of course, one of the issues that is in dispute, the argument that somehow these should have been named something different, given that they were used ultimately for hush money payment. So that's been one question, and we'll see where the jury goes on that. I think it's really hard to say whether or not he has proven his case on the second crime, because, Kyle, we don't know what the second crime is. This is the thing that is still just flabbergasting as an aspect of this trial. As you note, you cannot elevate this to a felony unless you can say that he committed this falsification in aid of another crime. And we have now made it all the way to the end of this trial. The prosecution in the beginning issued a number of things that it thought it could be, which ranged from breaking tax laws to breaking campaign finance laws. They have not specified it. And I think one thing that's also remarkable as we go forward, it sounds as though as we move into this jury instruction phase, that the judge is not going to require the prosecution to actually lay that out, but rather the jury will just be left to its own devices to decide whether or not some second crime was committed, and they can each make their own judgment on what that crime is and whether or not Trump is guilty of it.
The point about the second crime, I think, is a good one. To my eye, the prosecution has leaned into the argument that it is a campaign finance violation, that when Michael Cohen paid off Stormy Daniels, he was doing it for the purposes of protecting Donald Trump's political campaign. And that was, in effect, a campaign donation in excess of the federal limits on campaign contributions. One issue, though, Monet, is that I keep waiting for some direct evidence of Trump's knowledge of this and some kind of evidence that he was concerned that this payoff might be a violation of the campaign finance laws, because by itself, doing a non-disclosure agreement, paying hush money is not illegal. And I kept waiting for that evidence, and it kept not arriving. Most of these witnesses had no knowledge of what went on inside the Trump organization when this payment was being made, and then when the reimbursement to Michael Cohen was made. The defense team kept asking that. Stormy Daniels, for instance, Hope Hicks, you don't have any idea what was happening in Trump Tower with these business records, correct? This is a business records case. And those witnesses kept saying no. The one witness that really has some direct information is Michael Cohen. But even there, the distance between him and President Trump, I think, seems significant. So the repayment to him in 2017 from Trump to Michael Cohen, remember, was structured as a retainer. It was grossed up as if it was income. And here's a piece of what Michael Cohen testified. Here's the question. Was it Alan Whistleberg's idea that it should be grossed up? Alan Whistleberg, of course, is the longtime Trump Organization CFO. Michael Cohen agrees and says, and that it would be taken as income. What, if any, understanding do you have about why he grossed up that reimbursement? And here's what Michael Cohen says. I didn't know. And to be honest, I didn't really even think about it. I just wanted to get my money back. And Monet, that does not sound like a group of people who knew they were doing some kind of thing that was illegal and then were cooking the books in order to cover that up. It sounds like a group of people who were trying to make some payments and probably were not unfamiliar with making non-disclosure agreements. And it didn't even occur to them, maybe, that this was a campaign finance violation.
Yeah, absolutely. On the narrow question first of why those payments were grossed up and described as income rather than reimbursement, that seems to be part of the nature of a hush money payment, in the sense that if it had been described as a reimbursement, it would have been clear in the record keeping that this was returning cash to Michael Cohen for a payout of some kind, whereas describing it as income and grossing it up so that it would theoretically he would be able to pay taxes on it and still get the same amount back that he actually paid out is part of concealing that payment. And so that doesn't necessarily imply, as you suggest, that there was a crime that they were trying to conceal, but merely that they paid for this non-disclosure agreement and didn't want the object of the payment to be a matter of suspicion in the way that they were recording it. So that, from Michael Cohen, his inability to suggest that there was some kind of broader conspiracy at hand is exactly what you described. The prosecution failing to really prove that the structure of this payment was meant to conceal a campaign finance violation. But more broadly, I do think that the witnesses who the prosecution called, Michael Cohen and also Hope Hicks, were meant to insinuate that there was clear evidence that Trump decided to pay off Stormy Daniels because of how he thought it might affect the campaign. Hope Hicks said that she was aware at the time that he thought that the affair getting out would affect the campaign negatively, and it wasn't just that he was worrying about his marriage. And Michael Cohen said something very similar, that Trump was worrying, especially after the Access Hollywood recording came out, about how it could negatively affect his campaign. And the prosecution wants the jury to take a logical leap from that to the idea that they believed that Michael Cohen's payments could be construed as a campaign donation. But those two things are not necessarily directly linked, because Trump had some kind of fear of the Stormy Daniels story affecting his campaign does not suggest that Michael Cohen paying her off was a campaign donation, and the prosecution hasn't really proved that, as the case should require them to do. And so they're hoping, I think, that the insinuations from these witnesses will be enough for a conviction, when really they haven't connected the dots in the way that the law should require them actually to do, and they're going to rely on the jury taking this leap of logic.
Hang tight, we'll be right back in a moment. Welcome back. After prosecutors rested their case, President Trump's attorneys raised a relatively brief defense. Kim, give us a sense of what they did. I guess to my eye, it seemed like they were most focused on trying to impeach the credibility of Michael Cohen. And notable that one of their experts who was ready to testify, former federal election commissioner Brad Smith, said that the defense decided in the end not to call him because of limitations that the judge had put on what he could tell the jury in terms of whether or not this payment to Stormy Daniels was in fact not a violation of federal law.
Yes, well, let's step back. In the end, the defense called only one witness, Robert Costello. And Robert Costello was an advisor to Michael Cohen, and the clear reason for putting him on the stand was to once again attempt to impeach the credibility of Michael Cohen. And in particular, I think a couple of very damaging things that Costello said with regard to the prosecution. He recalled that in 2018, and this was in April of 2018, it was not long after federal authorities had raided Michael Cohen's office, that he said Cohen was in a panic and talked to him and said, "I don't have anything on Donald Trump." Costello also said that Cohen had told him that he alone had made the payments to Stormy Daniels, that Trump did not have a role in that. Now, you have to add all this to Michael Cohen's long history of being caught in lies. This was not the most credible witness you can have on. Now you have a defense witness flat out saying that he was told by Michael Cohen something absolutely different than what the prosecution is now alleging in this case. The prosecution did mount, obviously, a cross-examination. They tried to suggest that Costello has all along essentially been working on Trump's behalf, that he tried to control Cohen, and therefore he cannot be trusted on the stand. This is a former federal prosecutor. I don't think normally that would hold a lot of traction, but one thing that potentially did hurt the Trump team a little is that Costello was clearly at times visibly frustrated with some of the rulings that the judge was making, and this actually caused a confrontation. At a certain point, the judge actually cleared the courtroom and apparently dressed down Costello. And I think that's an issue because it was pretty clear that Judge Merchan had great annoyance, even a little bit of hostility toward this witness. And to the extent that jurors sometimes take their cue from the judges, I think that could be a bit of a problem for the Trump campaign. I think the other great tragedy here, and I find this very concerning, and it could well become an issue on appeal, is that, remember, you have this case that the prosecution has put forward alleging that some second crime has taken place. And as you note, Kyle, the strong allegation is that it's a campaign finance crime. The Trump campaign was going to bring former federal election commissioner Brad Smith to the stand to talk about campaign finance laws. And in particular, this argument that certain expenditures simply cannot be viewed as campaign finance related activity if they have to do with personal use. Brad has made a lot of arguments. For instance, joining a golf club might be useful for your political campaign because you meet a lot of other people and it gives you visibility, but you can't charge that as a campaign finance expense. Going and getting your wrinkles taken care of, to make yourself look more presentable is a personal use. You can't use campaign funds to cover it. And the argument being that you can't use a campaign to actually pay money to a former mistress. But the judge severely limited what Brad Smith was going to be able to say up on the stand to try to hem him into only talking about the most basic questions of definitions of federal election law. Made very clear that he was not going to let him make that argument. Said something about how, he didn't want to get into a battle of experts over this, which is completely odd because the jury should at least be able to hear an argument about campaign finance, given what's being alleged. And so in the end, the Trump team decided that given these limitations, there would be no merit to putting him on the stand. I think that could be an issue on appeal. I mean, the Sixth Amendment does afford everyone the right to mount a defense. And when you have a judge that is limiting testimony that would seem to go to the heart of the question of the defense, that is a concern.
Brad Smith is saying on X that he understands what the judge's concern was. He says it's elementary that the judge instructs the jury on the law. And I'm not an attorney, but my understanding is that juries are finders of fact, and they are supposed to be applying the law as it is explained to them by the judge. So the judge here did not want to have one expert coming in and saying this was a campaign finance violation, clearly, and another expert coming in and saying this is clearly not a campaign finance violation. But I agree with Kim that if Trump gets convicted here, this will definitely be a matter up on appeal. And she gave a few examples. Here's another one. Brad Smith speaking recently to the Washington Examiner. He's using an example if a business person is running for office and his businesses are getting sued. And he goes to his company lawyers and says, I want to settle these lawsuits against us. We've got some wage employment lawsuits and a woman is alleging sexual harassment. We've got 36,000 employees, but we've got these 3 complaints and the press will make a big deal about them. And Monet, his argument again is even if he's doing that for the purpose of influencing the campaign for office that he's running, those are clearly not campaign expenses. And the money that is used to settle cases is not an illegal campaign donation. And obviously, that is not the argument that is being allowed right now to be presented to the jury. But I have to say, I find it pretty persuasive, and I wonder whether appeals judges down the line will be persuaded by it.
I think that there's little doubt that they will, and that fact is the reason why the prosecution hasn't actually gone out of their way to demonstrate the ways that they believe that Michael Cohen's payment to Stormy Daniels was a campaign finance violation. If they really believed that that was an airtight argument, they would have spent the duration of the past few weeks trying to lay that out for jurors to understand. Instead, they've chosen a different approach, which is to be as vague as possible about what the underlying second crime that they believe the illegal record keeping was meant to conceal was, because they know that the actual campaign finance law does not suggest that the non-disclosure agreement that the Trump organization constructed actually would be construed as a campaign finance violation. And so we have a very, very odd structure in this prosecution, of course, as listeners will know by now, wherein Alvin Bragg is bringing these state law charges, which can only have substance if they're connected to another underlying crime. They might not, for the sake of a conviction in this particular case, have to demonstrate exactly what that crime is. And yet they know that they're essentially building a sandcastle here, because if they don't have that second underlying federal crime well demonstrated and aren't able to do that once they reach that venue and the case is reheard on appeal, then it's all going to fall apart, which is just more evidence that this case is being brought for reasons other than the fact that they believe they have an airtight legal case against Donald Trump, that they felt motivated to bring it for political reasons and are deferring the hard substance of that underlying crime that they think he's guilty of, because they know that it's not required for this first round of getting a New York State conviction.